If you are living in the United States as an immigrant right now, or if you are trying to get here, the last week of April 2026 brought a wave of policy updates that could directly affect your green card, your asylum case, your work permit, or your visa application. And the reason we are making this video right now is simple. Most people have not heard about any of this yet. 3 separate government agencies, USCIS, the Department of Homeland Security, and the State Department, all issued new guidance within days of each other in late April 2026. And while each one matters on its own, the fact that they are all happening at the same time means that immigrants across nearly every category are now navigating a more complicated, more expensive, and more uncertain system than they were even a month ago. In this video, we are going to walk through each update clearly: what happened, what it actually means, and what you should be doing right now. Stay until the end, because the action steps at the close of this video are just as important as the news itself. Let's start with what broke first. In late April 2026, internal guidance issued by US Citizenship and Immigration Services directed immigration officers to implement what the agency is calling enhanced security checks for immigration applicants. Here is the background. A February executive order from President Trump directed the Justice Department, which oversees the FBI, to give USCIS greater access to federal criminal databases. Specifically, the order called for access to criminal history record information to the maximum extent permitted by law. Acting on that order, the FBI granted USCIS expanded access to its Next Generation Identification System, a major federal criminal history database. And in response, USCIS sent internal guidance to its officers, instructing them to ensure that pending cases go through these expanded checks before being approved. What that means in practice is that many pending applications, especially those where fingerprints were submitted to the FBI before April 27, 2026, may now experience delays while that background information is reprocessed through the upgraded system. A USCIS spokesperson confirmed publicly that the agency has implemented new security checks to strengthen the vetting and screening of applicants through expanded access to federal criminal databases. The agency added that any delay in decision issuance should be brief and resolved shortly. Now, we want to be precise here because precision matters. USCIS has not publicly stated that every single pending case in the country has been frozen. What the internal guidance shows is that officers were directed to ensure enhanced checks are completed before approvals go out, and that has led to pauses in processing for a significant number of cases, particularly in adjustment of status, naturalization, and asylum filings. If you are waiting on a green card, a citizenship application, or an asylum decision from USCIS, your case may be among those experiencing a delay right now because of this. The applications most likely affected include the I-485, which is the adjustment of status form for green card applicants, the N-400 naturalization application, and asylum cases processed through USCIS's Refugee, Asylum, and International Operations Directorate. What do? USCIS has confirmed that applicants do not need to submit new fingerprints or take any special action. The agency is rerunning fingerprints already on file internally. You do not need to contact USCIS to request this. However, if your case is time-sensitive, meaning you have a job offer contingent on your green card approval, a travel situation that depends on your pending case being resolved, or a citizenship ceremony scheduled, this is the moment to get in front of an immigration attorney who can assess the specific impact on your timeline. USCIS said the delay should be brief, but the agency did not define brief, and in immigration, undefined timelines can stretch for months. So if you have anything time-sensitive riding on a pending USCIS case, do not assume it will work itself out. Be proactive. Now let's talk about the second major update, and this one has a hard date attached that you cannot ignore. On April 28, 2026, the Department of Homeland Security announced an interim final rule implementing new immigration fees and requirements under the H.R. 1 Reconciliation Act of 2025, commonly referred to as the One Big Beautiful Bill Act. This rule is set to take effect on May 29, 2026. That is weeks away, not months, weeks. And if you have a pending asylum case, or if you are on temporary protected status, or if you have been relying on an asylum-based work permit, this rule affects you in a direct and immediate way. Let's go through what it actually does. The most significant change is the introduction of an annual asylum fee, called the AAF, for people with pending Form I-589 asylum applications. This fee is $102 per calendar year that the asylum application remains pending. If USCIS sends you a notice that this fee is due, you have 30 days to pay it. The rule as written states that failure to pay within that window can result in USCIS rejecting the pending asylum application. For people who have no other lawful immigration status at the time of rejection, the rule indicates that USCIS may initiate removal proceedings. Now, we want to flag something important here. While this is what the rule says on paper, immigration attorneys and legal experts note that USCIS typically includes procedural steps and notices before consequences this severe are carried out. The rule is new, the implementation is just beginning, and the exact enforcement process for non-payment situations will become clearer over time. What is not unclear is that the fee is real, the 30-day window is real, and the stakes for not responding to a notice are serious. The rule also states that if the annual asylum fee is unpaid, USCIS can deny or decline to renew an asylum-based employment authorization document, your work permit. Losing your EAD can also affect your driver's license in many states, since valid work authorization is often tied to driving privileges. Beyond the annual fee, the rule raises the cost to renew an asylum-based work permit, the I-765 in the C8 category, to $275. It also retains the $100 filing fee for the initial Form I-589 asylum application, a fee that did not previously exist for affirmative asylum applicants before H.R. 1 became law. And it introduces a minimum $24 fee for Form I-102, which is the application for a replacement or initial non-immigrant arrival departure document. For people with temporary protected status, TPS, the rule also shortens employment authorization validity. EADs for TPS holders will now be valid for 1 year or the remaining TPS designation period, whichever is shorter. That means more frequent renewals, more filings, and more administrative steps just to maintain the right to work. So what do you actually do with this information right now? If you have a pending asylum case, go to your USCIS online account and check whether any fee notices have been issued on your case. Do not just wait for something to arrive by mail. And this next part is critical. Make sure the address USCIS has on file for you is current. The 30-day payment window starts when USCIS sends the notice, not when you receive it. If USCIS sends a notice to an old address, the clock is still running. If you have moved since you filed your case, update your address using Form AR11 and confirm the change in your USCIS online account before the May 29th effective date. If you are a TPS holder, check when your current EAD expires and plan your renewal earlier than you normally would. The shortened validity window means renewal timelines are now tighter, and missing a filing window could create a gap in your legal work authorization. If you are an employer with workers whose employment authorization is based on pending asylum cases, now is the time to audit your Form I-9 records and identify who may be affected by upcoming EAD renewals or potential delays. The effective date is May 29, 2026. That is a firm date. Whether you need to pay, update your address, or plan for a renewal, now is the time to move. Now let's discuss the third development, and this one is directed at people trying to come to the United States from abroad. On April 28, 2026, The State Department issued a cable to diplomatic missions, US embassies and consulates around the world with new guidance on how consular officers should conduct non-immigrant visa interviews. The cable, which was reported by multiple major outlets, including the Washington Post and CNN after they reviewed its contents, instructs consular officers to ask non-immigrant visa applicants 2 specific screening questions as part of the interview process. The first question: have you experienced harm or mistreatment in your country of nationality or last habitual residence? The second: do you fear harm or mistreatment in returning to your country of nationality or permanent residence? According to the cable, consular officers are directed to look for applicants who answer no to both questions before proceeding with visa issuance. The instruction from the State Department is that applicants who indicate fear of returning home should be evaluated more carefully, and in many cases would not move forward to visa approval. Multiple major news organizations have reported that the practical effect of this guidance is that applicants who answer yes to either question are likely to be denied the non-immigrant visa at the consular stage. This applies to tourist visas, student visas, and temporary work visas, including H-1B and J-1, among others. Now, here is the legal context that you need to understand to fully grasp why this is significant. Under US law, the right to seek asylum requires physical presence in the United States. You must already be on US soil to file an asylum application. The Trump administration has described the concern behind this new directive as preventing people from using temporary visas as a pathway to enter the country and then claim asylum after arrival. The cable from Secretary of State Marco Rubio's office stated that consular officers must prevent what it called misrepresentation of the purpose of travel by applicants attempting to obtain non-immigrant visas in order to later claim asylum inside the United States. But here is what immigration legal experts are pointing out, and this is important. If someone answers no to both fear questions in order to obtain a visa, and they later seek asylum after arriving in the United States, those consular interview answers could potentially be referenced in immigration proceedings. Immigration policy consultant Camille Mackler told CNN that this directive puts people in very difficult positions, where choices about how to answer questions at an embassy could directly affect their safety and their family's safety. She also noted that restrictive policies at the legal entry level tend to push people toward unofficial and unsafe routes, because if someone genuinely needs to leave their country, they will find a way regardless. One important clarification: if you already hold a valid, unexpired US visa, this new questioning requirement does not apply to you unless you attend a new consular interview for a visa renewal or a new application. Travelers from visa waiver program countries who use ESTA and do not attend consular interviews are also not currently subject to this specific directive, though other additional screening measures have been separately introduced for that category as well. For anyone planning to apply for a US non-immigrant visa in the coming weeks or months, whether for tourism, study, or work, be aware that the visa interview process has changed. If you have specific concerns about how to navigate these new questions, given your personal circumstances, speaking with an immigration attorney before your interview is the right move. Now let's pull back and look at what all of this means together. In the span of just a few days in late April 2026, the immigration system in the United States shifted in ways that affect people at virtually every stage of the process. People already inside the system with pending cases are now dealing with delays tied to expanded FBI background checks. People with pending asylum cases are facing new mandatory fees and serious consequences for non-payment, with an effective date less than a month away. People trying to enter through legal channels from abroad are now navigating a consular screening process that is more restrictive and more consequential than it was before. Many immigration attorneys and policy experts are describing this period as one of the most significant and fast-moving phases of immigration policy change they have seen. Whether you agree or disagree with the direction of these changes, the practical reality for immigrants is the same. The rules are different now, and you need to know what has changed. So let's close with what you actually do from here. First, if you have any pending case with USCIS, log into your online account. Check your case status. Make sure your address is current. Do this today. Second, if you have a pending asylum application and it has been pending for more than 1 year, prepare for the annual asylum fee. Understand what USCIS will be sending you. Make sure they can reach you. And if you have concerns about your ability to pay or about your specific case's status, talk to an immigration attorney now, before May 29th. Third, if you are a TPS holder, plan your EAD renewal earlier than usual, given the shorter validity window under the new rule. Fourth, if you are planning a non-immigrant visa interview at a US consulate, know that the interview process has been updated with new screening questions. Understand what the questions are, what the guidance says, and if your situation involves any complexity around fear or safety concerns, consult an attorney before you sit down for that interview. Fifth, if you are an employer, audit your workforce now. Know who has pending cases, when work authorizations expire, and what your exposure is if processing delays continue. And finally, share this video. There are people in your community, in your family, in your workplace who are directly affected by these changes and do not yet know they happened. A share takes 5 seconds and could prevent someone from missing a deadline that changes their life. Drop any questions in the comments below. We read them and we will do follow-up videos on any part of this that you want to go deeper on. Subscribe if you are not already here, because this is moving fast and we will be back as soon as there are new developments. Stay informed, stay compliant, and take action today.